Roseanna Cunningham. 6 to 7 minutes, Minister.
Thank you, Presiding Officer. Today's debate has given us the opportunity to discuss issues around transparency and conflicts of interest and whether a register of judicial interests would address these. I sense, however, that much of this debate has really been about the process of getting here. Members will forgive me if I don't get too drawn into that aspect of the discussion. It's not really for me to intervene in the procedures of either committees or calling of witnesses, etc. And I'm sure if there are concerns expressed about that, they might be taken up in another place. The debate also did range rather more widely than the motion might have suggested it was going to, and that is understandable. We've heard differing views expressed about the need for a register of judicial interests, and as I indicated, some contributions went very widely indeed. Now, an exchange of views is always welcome. We all recognise the importance of the need to ensure judicial independence and, of course, judicial accountability and transparency. But as I said in my opening remarks, there are already key safeguards in place to ensure both the independence and the accountability of the judiciary. And these important safeguards are, to repeat, the judicial oath, the Statement of Principles of Judicial Ethics issued by the Judicial Office for Scotland in 2010 and the Judiciary and Court Scotland Act 2008. And this debate has given us the opportunity to put that on the record, that these do exist. We've seen it from the debate this afternoon that if the Lord President was to introduce a register of judicial interests, there's a wide breadth of interests that may need to be declared. As raised by a number of members, amongst them Stuart Stevens and Graham Pearson, material relationships may, in many cases, be more relevant than pecuniary interests. And I think I'm right in saying that it was David Stewart who described a situation where a judge had had to recuse himself because he'd been at a social event as one of the key lawyers in the case. And I don't want to misrepresent what he said, but I think that was my recollection. It was along those lines. But frankly, if you take that too far, you'll either have to cloister judges permanently or no cases would ever be heard, because the way our social relationships work in Scotland make it almost impossible to avoid that happening on a number of occasions. For giving way, and I understand the point she's making. Could the Minister just say something, though, about the point I've made a couple of times, that this is not all new, and before the Supreme Court, that law lords registered their interests day and daily for generations. So there's an assumption this is all new. This is not all new. Perhaps the member would allow me to actually get into the speech, because I do indeed want to come back to that particular point. But we've also heard how action is being taken by the Lord President to increase transparency in this area. The Register of Judges recusals recently set up by the Scottish Court Service is an excellent example of this, and over time it will give us a better understanding of how that process works. Now, I'm sure the Lord President will read the report of this debate and the contributions of various members with interest, so I'm not going to be drawn into a discussion of his decision regarding attendance of the committee. However, as referred to by John McAlpin and others, I'm not quite sure if I remember who, he has warned that the introduction of a register of judicial interests could have unintended consequences. In his words, consideration needs to be given to judges' privacy and freedom from harassment from the media or individuals, including dissatisfied litigants. And if publicly criticised or attacked, a point that hasn't been raised by anybody is that a judicial office holder cannot publicly defend him or herself, unlike a politician. We have the opportunity to respond to criticism. A judge would not. So they don't have the same right of reply that we have. And I have to ask, what would be included on a register? If we're agreed that it is far less likely to be financial interests that create problems than it is to be social, familiar and other relationships, it would have to somehow encompass those. But a register including those relationships would be very difficult to compile. Family trees, friendships, all sorts of organisations and affiliations would have to be included. And I think Neil Findlay even seemed to suggest that religious affiliations should also be included. How on earth to know in advance what might or might not cause a problem in a case as yet unseen. And it's interesting that all members contributing this afternoon have avoided reference to a register in anything other than very general terms. But it is equally clear that it is assumed such a register would go beyond the financial. And I've outlined some of the issues I think would arise once it was given closer consideration. Now, if I come to the point raised by David Stewart in respect to the situation in the House of Lords prior to the creation of the UK Supreme Court, as I understand it, that was confined to financial interests. It was not the kind of register that people have generally discussed this afternoon. And furthermore, when the Supreme Court was set up in 2009, that financial register, it was decided, would not be continued, and instead a code of judicial conduct was drawn up. So it isn't an analogous register to what has actually been discussed by members, and I think we should understand that. We should also take heed of the outcome of the report of the Council of Europe Group of States Against Corruption. I want to just reiterate that that is an important objective assessment of where we are in terms of the judiciary in Scotland and indeed the United Kingdom. I am aware that others take a different view about the need for a register. The former Judicial Complaints Reviewer considered that it would increase transparency and public trust. As I said earlier, it would be for the Lord President to establish such a register of interest in his capacity as head of the Scottish Judiciary. But as a government, we do not consider that there is currently any evidence to suggest that the existing safeguards are not effective, and we don't consider that such a register is necessary. Indeed, some of the issues that have been raised this afternoon should point to how difficult it might be to compile the kind of register that people think may be appropriate. Now, a number of members did refer to the Register of Interest for MSPs, but that is very different because we are directly accountable to the electorate. That's why the register exists for us, and even for us, things like religious affiliations are not required to be registered, neither are our circles of friends and relatives, and all the kinds of social relationships that give rise to some of the suspicions in respect of judges. So the debate has provided the opportunity to consider all of these issues. I assure you we will continue to keep these issues under review, but our current position is it is not necessary.
Thank you very much. I now call on Mr.